Good morning, good afternoon, and good evening, viewers. Welcome to the first webinar that we want to host on WTO Dispute Settlement. The question we are posing, debating, and ultimately answering today is, can the Multi-Party Interim Appeal Arbitration Agreement, the MPIA, save WTO Dispute Settlement? My name is Geneva and I am the Deputy Director at the Sridath Ramphal Center for International Trade Law, Policy and Services at the Cave Hill campus of the University of the West Indies. Over the next hour and a half, our aim is to educate you about the MPIA and its consequences, excite you with the riveting debate from my fellow panelists, and provide a forum for executing reform at the WTO, whether that comes through improvements to the MPIA or other alternatives outside of it. I have 4 capable guest panelists, specially selected to assist me in this task because they are no strangers to the WTO and they come from various vantage points. Mr. Mustaqim Dagama is a counselor with the South African Mission in Geneva, and he covers areas at the WTO, such as the dispute settlement body, TRIPS, TRIMS, etc. He used to head the Legal International Trade and Investment Directorate in South Africa. I also have Ms. Kellyanne Shaw, a partner with Hogan Lovells in Washington, D.C., who prior to that post served as the Deputy Assistant to the United States President for International Economic Affairs and the Deputy Director of the National Economic Council. Mr. Claude Chase of Aiken Gump Associates in Geneva, who like me is a St. Lucian, who has served at the Dispute Settlement body at the Appellate Body Secretariat at the WTO. And finally, Ms. R.V. Anuradha, she's a partner at Claris Law Associates in New Delhi and heads her firm's practice in international trade and investment law and policy, teaches and writes often on WTO and investment law. So they're literally from all over the globe, and I welcome them. I will start today's session by providing an overview of the MPIA to level set. And we will then hear from our man on the ground, Mustaqim, who's in Geneva, about what's happened under the MPIA since it was first notified to the DSB, at the end of April. I will then turn to the 3 main themes we want to explore today. For each, we'll cover about 15 to 20 minutes of discussion, and we'll hear the panelists' views. We will reserve around 15 minutes at the end for Q&A, and you can ask your questions in the window of the Zoom call at the bottom, and we will funnel them to the panelists to get some answers. At the end of the program, so that you can answer the question posed by this discussion: can the MPIA save WTO dispute settlement? So let me start off with the overview. The MPIA. So the failure to appoint new judges to the appellate court of the WTO, the appellate body, as of December last year, meant effectively that the appellate body as we know it is no more. There are many immediate and longer-term systemic consequences of this loss, but one of the immediate concerns is that once a panel report, and that's the first instance deciders of law and fact, issue a report, ultimately there is a risk because the appellate procedures remain in the text of the dispute settlement understanding. The risk is that the losing party would appeal and activate these procedures to an absent appellate body, meaning that the panel report will not be adopted and ultimately made binding. This phenomenon has been called by DS experts appealing into the void. There's no adoption of the report and no resolution of the ultimate dispute. In the longer term, the loss of the appellate body means there's effectively no second tier of review. So a number of countries have come up with a proposal to use an arbitration procedure provided for under Article 25 of the Dispute Settlement Understanding to run a mimic of an appellate body procedure. They propose that this will only be
a temporary solution until the WTO appellate body is reformed or a new body is put in its place. It is open to all WTO members who can simply join by notifying the DSB. From my count so far, there are 21 countries who have signed up to this MPIA, including Australia, Brazil, Canada, China, Chile, Colombia, Costa Rica, Ecuador, the European Union and all its member states, Guatemala, Hong Kong, China, Iceland, Mexico, New Zealand, Nicaragua, Norway, Pakistan, Singapore, Switzerland, Ukraine, and Uruguay. Now, it was important for me to spell all this out because notably absent are countries like members of the ACP, Africa, Caribbean, and Pacific countries, larger developing countries that are no strangers to dispute settlement, like India, South Korea, Indonesia, as well as extremely litigious countries like the United States and Japan. So what are the key features of this MPIA? And I just mentioned a few. First of all, as intended by its proponents, it is really meant to be an interim measure, as long as the appellate body is not in existence. The MPA parties agree not to pursue appeals or to prevent the adoption of first instance panel report by the DSB. The MPIA sets up a procedure to appoint a pool of 10 arbitrators. Each party to the MPIA can nominate one person to that pool of arbitrators, and a selection committee comprising the WTO's Director General, the chair of the DSB, and chairs of the WTO councils will then screen candidates to ensure that they meet MPIA selection criteria. Notably, present and ex-appellate body members are not required to undergo this pre-screening. At the end of that process, the MPIA parties appoint 10 arbitrators from the screened group. With some exceptions, the Article 25 MPIA procedure will generally try to mimic the appellate body review procedures, but there are some exceptions. For instance, arbitrators will be empowered to encourage procedural efficiency, for instance, page limits, time limits, and they can even recommend to an appellant, to two parties on appeal, to abandon certain claims, including claims relating to the panel's assessment of the facts. Each appeal under this MPIA will be heard by 3 of the 10 arbitrators chosen, who will, just as the appellate body does in the context of a dispute, have an exchange of views with the other 7 members of the arbitration court. Arbitrators are to be provided with the appropriate administrative and legal support, which will offer the necessary degrees of guarantees of quality. And the support staff would be structured to be separate from the WTO Secretariat. So in sum, these are the basic tenets or key features of this MPIA agreement, which is set out in 3 main parts. I've given you the basics, and now I'm going to call on our panelist, Mr. Mustaqim Dagama, our man on the ground, as I mentioned, to lay out for us, well, what has happened since this MPIA was first notified to members and to the dispute settlement body in April earlier this year. Mustaqim.
Thank you, Geneva. Good evening, good afternoon, good morning, wherever you are. I'm going to try to be as efficient as possible. I think, as Geneva indicated, the notification triggered various paragraphs of Annex 2, and so members were required to select, or at least select a candidate and to notify the selection in terms of paragraph 1 of the of Annex 2. What has happened, and I can confirm that members have selected their candidates. These have been received, and certainly what the DG is to convene a selection committee that will look at these particular CVs. Now, I wanted to point out that in the first instance, these procedures have started but are not concluded yet. And so it is anticipated that the pre-screening process, which is prescribed, will be completed by the end of June. So the DG has convened, I think, 1 or 2 meetings of this selection or screening committee. And what is apparent currently is that it seems that there are more than 10 nominations which have been submitted by the member states. The second aspect would be that given the fact that the MPIA envisages that these positions could also be open to current and former appellate body members, from the information that we currently have is that none of current or former appellate body members have actually applied to be part or at least to be candidates in this particular process. And so the DG and of course the selected chairs of the various bodies will probably consider these particular issues. I have to say there is one small complication in the sense that at least 2 of the chairs that are cited or at least requested to participate have declined to participate. And so on that basis, it may be a smaller group of ambassadors that will consider these particular issues. Just quickly moving on, I think a second aspect that I just want to quickly highlight is on the issue of budget. Now, many people would have read that on the 3rd of June, the budget committee met, but I have to declare that not much was learned from this particular meeting, because what the proponents of the MPIA have put on the table is that the activities envisaged under Article 25 are fully covered in the regular budget for dispute settlement. And so from that point of view, the establishment, for instance, of a special fund, which would by the members of the MPIA, has not necessarily come up. But what is quite interesting from this particular meeting is the report of the so-called Office of Internal Oversight. And we will also recall at some point the US had raised issues around the remuneration of appellate body members. And so an audit was instituted, and the basic finding here is that the appellate body budget expenditure has decreased. But what is fundamentally clear is that on the other side, the budget for panel proceedings has actually increased and actually overshot by 138%. So if we are members to utilize the regular budget, there may be issues of cost which should be addressed in some way or another. We know that the DG has been allocated quite a substantial role here, but in the end, we are not clear necessarily how the budget will be allocated. Lastly, Geneva, I just wanted to quickly report on a further development, and this is the letter that was received from the US with regard to the MPIA. Now, I have seen the letter, and seemingly the US does not raise necessarily a concern with the use of Article 25, but what they seem to do is to raise concerns with the way the MPIA members have chosen to implement the MPIA. And so they, for instance, referred to the objective of the MPIA, the fact that it is likely to exacerbate what they call the worst excesses of the appellate body. And certainly they raised the issue of budget because they are of the opinion that Article 25 goes way beyond what is envisaged under that particular provision, especially because it calls for a freestanding or what they call a new division to support the activities of arbitrators. Geneva, there's many other cross-cutting issues that I will pick up a bit later in our thematic discussion. So I leave it at that and I hand over to you. Thanks.
Excellent. Well, thanks for that. I think we are set now to understand what the MPIA is, what developments have already taken place. The selection process has started. There are some issues that have been raised by certain key members about through letters and maybe through gossip on the ground. I want to get the perspective of the panelists, who, as I mentioned, really are no strangers to this dispute settlement system, and really we've gotten from all corners of the globe, and can present in their personal capacity their views on what the MPIA represents for dispute settlement. We're going to start just looking at sort of the risk-reward discussion of this MPIA. Why should non-participating countries, so the countries other than those who have already signed up, which is really just 21 members, but with the EU, it might be more with the EU members, but why should these non-participating countries care about the MPIA? What are the immediate or longer term consequences for the system that you can envisage? What are alternatives to the MPIA, and why aren't WTO members putting forward other solutions if there's such a limited uptake of the MPIA so far? So I'm going to throw that question out, looking at risk-reward of the MPIA dispute settlement system for non-users, for users. What does this mean for our dispute settlement system? And I've asked my panelists to jump in. Anyone on this topic? So maybe I'm going to call.
Geneva, let me go.
Okay, please go ahead, Mr. Kim.
Yes, thank you. I don't want to hog the floor, but certainly when we look at the cost-benefit analysis of the MPIA, we have to ask ourselves a fundamental question. And I think the question that we pose is, will the MPIA save the dispute settlement system? And I can say from my vantage point, it would depend who I'm speaking as, but certainly on the face of it, I don't understand that the MPIA is a complete statement. I think it has to be taken in context. The first is that it is part of what we call history, and certainly there is unfinished business. And so if we look at the MPIA in this context and the systemic implications, we have to ask ourselves as developing countries, what has happened to the Doha round? And of course, dispute settlement forms part of this particular debate. And so we will also understand that as part of the Doha round and addressing some of the deleterious consequences of the Uruguay round on developing countries, and certainly some discomfort that many other members of the WTO would have had with dispute settlement, there is an ongoing process in the dispute, in the DSB in special session, which has been ongoing for the last 25 years. Now, if we look at the MPIA, it is totally devoid of any provisions that cater for the interest of developing countries. And so one would, in an objective way, say, but why is it that a subset of members can all of a sudden harvest certain issues, propagate them, and benefit from the financial resources of the institution, whereas many issues that have been raised by developing countries have not been taken up. And so many people are skeptical about the development credentials of the MPIA. They are skeptical about the inclusive nature of the particular initiative. And certainly the WTO is replete with examples of temporary or interim agreements that have become permanent. And so just think of the GATT and its provisional application. And certainly so, I would think that there could be many concerns on a systemic basis. But if we look at some of the other systemic issues that would arise, and I certainly know that some of my colleagues will come in here, the issue of precedent, for example, is another systemic matter that certainly should be taken seriously, because even the proponents of the MPIA are not able to explain exactly how an arbitral award, which is rendered, will configure within the context of a fully functioning appellate body once it is reconstituted. What would be the status of that particular award? Would it have the same status of unadopted awards, for instance, or panel reports under the GATT system? What would be the precedent value in respect of members that are not participants in this particular procedure. And so just in ending, Geneve, the other issue is the issue of power dynamics and the bilateralization of dispute settlement. I think upfront, this development certainly does create, would create a few issues that non-members would have to confront at the time when a dispute arises. And certainly developing countries, especially those who have not used or who are not frequent users of the system, may be at a disadvantage given the power dynamics that would be at play. Thanks.
Well,
I'd like to chip in.
Jump in.
Okay, yeah. At the first count, I completely agree with Mustaqim's points in terms of the power dynamics and the various issues of developing countries which haven't been addressed adequately enough. But at the same time, I think we need to separate the issue of MPIA from the overall problems that face the WTO. There are multiple issues, there are aspects which need to be resolved, and the MPIA certainly is not a panacea for all of that. I think the MPIA really needs to be looked at in context, and the context for that is the fact that we have been operating under a suboptimal appellate system since October 2018, which is when the stalemate really started with the non-appointment of members. In December 2019, when the entire process, as you explained, the appellate body itself came to an end, the choice for members was to let it lapse, and I think the implication of that would really have meant, and the implication of that means that there is really no effective dispute settlement process available at the WTO. So the larger question is, which as you very nicely explained in the introductory remarks, is what without an effective enforcement and implementation mechanism. I think it was also Professor Vanden Bosch in his the retirement speech that he made at the WTO captured it very effectively by saying that the end of the appellate body will really mean an end of dispute settlement process as we know it. And what that means for the WTO as a whole, will the agreements that have been negotiated, that have been effective, that have been implemented and enforced in the last 25 years, what will happen to all of that? Will it actually lead to a spate of unilateralism? And then the other very important context is the Walker process, the fact that there was an attempt which was made by the chair, David Walker, to actually bring together and resolve certain issues. And many of the aspects that the US had raised as problematic aspects of the appellate body was sought to be addressed. But that process also failed. So the choice for members was what next? And the 21 members that have come together for the MPIA, I think, are really launching on an experiment. And I really see the MPIA as a unique experiment. It's only by a small group of WTO members, and its success or otherwise really is something which needs to be seen with experience. But this process in itself, could it realistically have amended the DSU by itself as a whole? You've already pointed out the few aspects on which certain exemptions or certain deviations from the appellate process as we know it have already been built into the MPIA, but these are not aspects which are prescriptive. These are aspects that, as you mentioned, for example, the limited use of Article 11 on the opening of factual related aspects, the fact that members will refrain from aspects relating to opening up issues on domestic law, for example, the timelines, the procedural aspects. These are all aspects which have been built into the MPIA, but these are left to the parties to actually work out on a dispute by dispute basis. As we know, 3 disputes have already kickstarted the MPIA process. I think two disputes that Canada is involved in, and the other between I think Costa Rica and Mexico have already expressed the view that the MPIA process will follow after the panel reports are out in the event the appellate body has still not been constituted. So I think this is really a very important aspect to remember, that this is an experiment by these 21 countries. and all the other nitty-gritties on procedural aspects, budget-related issues notwithstanding. I think the importance of the fact is that Article 25 is a part of the statute, is a part of the DSU. It did not envisage a separate budgetary process. Whether there has to be a permanent secretariat servicing the pool of arbitrators is a tricky question, I agree. But in principle, there would be an appellate review process through arbitration is, I think, an extremely important development, which I think non-participants would be particularly interested to see how it manifests. I don't necessarily see it becoming permanent, because the permanence of it would really depend on more members buying into it. If it is going to be a small group of members, permanence doesn't really make sense.
I think we have a great basis for others to jump in. I'm hearing very positive things from the last intervention about it being an experiment. I'm hearing some concerns about it being maybe not as overtly developing country centered. I wonder if Kellyanne or Claude wanted to say anything about, yes, it is temporary and it's an experiment, but what are the chances of it? I think I saw a letter by the United States saying it's perpetuating the inefficiencies of the appellate procedure. Claude, I wonder if you have anything to add, and then Kellyanne jump in right after.
Yeah, sure. Thanks, Genevieve. From my vantage point, I think, a lot of the points that these are legitimate points, and there are definitely risks that are associated with the MPIA. On the other hand, I really agree with Anuradha that we need to contextualize this. I don't think we can expect of the MPIA that it's going to solve long-standing issues that have faced the WTO. I don't think the MPIA is going to address legitimate concerns about the extent to which the WTO deals with country issues. I think the MPIA it's a very targeted measure that is meant to address a specific situation. And the situation that we face now, in reality, is the absence of one of the main functions of the WTO, which is its dispute settlement function. That is the situation that we are faced with now, because the absence of the body means, in effect, the lack of binding dispute settlement at the WTO. And from that perspective, if that is the situation that we face, then I see the benefits of the MPIA as far outweighing risks that may or may not materialize. So for example, with respect to the MPIA becoming permanent, that may be a risk that would materialize, or it would not. I think that really depends on the extent to which members are serious about recomposing the appellate body. So I think it's easy for us to look at the MPIA and see its flaws. It may be suboptimal, but if these risks are in fact credible risks, then the response should be to recompose the appellate body at the earliest, so that we could have binding dispute settlement. I think from a practical perspective, we've reached a point now where I don't think any of us believe that that's going to happen in the short to the medium term. And so we do need a credible interim solution that will ensure that we can have binding dispute settlement at the WTO. Because I think the absence of binding dispute settlement is going to have knock-on effects on the system. If you don't have binding dispute settlement, what is the point of negotiating, for example, new rules? There's no point in negotiating new rules that can actually be enforced. With respect to the US letter about this perpetuating the criticisms of the appellate body, the drafters of the MPIA, I think, they've been sort of conservative in taking an approach that mirrors what is already in the system. I don't necessarily think it would have been a good thing for them to have tried to have reformed the system in developing what is supposed to be an interim measure. If the measure is interim, then I think the more prudent thing to do would be to stick as closely as possible to the current system that you have. And then we can discuss broader reforms in the context of a more permanent solution.
Kellyanne, as you jump in, I hear Claude talking about this idea of it being a binding dispute settlement system, as if the loss of the appellate body signals that the system will no longer be binding. And I wonder if you had any, I mean, you could recreate a system where at the panel stage, that would be the end and the panel reports would be binding as such. So I'm not sure if you had anything to respond, but to that specific criticism, but just more generally, if you had anything to add.
Yeah, certainly, Geneva, and thank you so much for organizing with such a great group of panelists. I will say at the outset, I worked for the US government for 10 years, including 3 in Geneva, but I left in November, so my views are completely my own. I was not involved in the US perspective on the MPIA at all. But just based on my own experience in litigating cases and in negotiating in Geneva on the GSU review, you know, I think that it is a bit unfortunate that the appellate body has become synonymous with the dispute settlement mechanism in the WTO. And while I certainly think that the appellate stage is an important one, and it was a choice that members made to include that, you don't need an appellate stage necessarily to have effective enforcement of commitments. And if you look at the DSU, which for those who may not be familiar, is the agreement in the set of WTO agreements that outlines the rules of procedure and the entire dispute settlement mechanism, you have a variety of tools and a variety of stages. You have consultations. You also have the panel stage, which makes up the bulk of the agreement. You have mediation, good offices. You also have arbitration under Article 25, which is what we're talking about when we're talking about the MPIA. And then you have the appellate function, which is just one chapter in the entire agreement. And for those who were involved in negotiations, it was really an afterthought. It was added at the very last moment, and it was considered to be something that would only be used in the most egregious of circumstances where there was a severe misinterpretation by the panels as to what that provision meant. So, you know, it really has taken on a life of its own over the last 20 years. And the DSU review, it was started shortly after the DSU was negotiated. The leaders and ministers gave member countries 4 years to review the operation of it and said, you know, if there's anything wrong, if you need to modify what's happening, we'll engage in negotiation. Do that. And it was a 20-year negotiation that went on. I represented the United States for 3 years of it, where we raised exactly the same issues that the United States is raising today under a previous administration. For the United States, there are completely bipartisan concerns about whether the appellate body is sticking to its own effective rules of procedure, whether it's engaging in judicial overreach. So I do disagree with the premise that, you know, we've been operating under suboptimal appellate systems since 2018. Because if you do ask any US negotiator or official, it's been suboptimal for much longer than that. So it's really a matter of perspective, and that is certainly the US perspective, and other member countries take a different view as to the importance of it. But I lay all this out to say that, you know, there are a lot of ways to enforce obligations and agreements, and we see that in the WTO, we see that in all of our bilateral trade agreements, we see it in all sorts of treaties. And nobody is arguing that you don't need effective enforcement. You certainly need to make sure that the words on the page are worth more than the ink that they're written with. You need to ensure that other countries are going to abide by them, and that countries themselves are held to the standards that they agree to when they make those commitments. An appellate system is a choice. It is not essential. That said, we certainly have a problem right now where what happens when you get to the end of a panel stage, it is a legal question, and some country appeals into the abyss, and we need to solve for that problem. I think that the creators and the architects of the MPIA have come to one creative solution in doing that, and I certainly think that member countries can make whatever arrangements they want. But there could be other ways. The United States, for instance, came to an agreement with Korea in the OCTG case, where they signed a sequencing agreement and said whatever the outcome of the panel stage is, it will be binding. And regardless of what it is, we will abide by that. That is certainly another way to deal with it. You know, I don't really take a view on the MPIA other than to say I do see that it does exasperate some of the problems with the appellate body and seems to bring it further away from member control. It also, even on issues like the 90-day issue, as to whether or not the appellate body was going to issue reports within 90 days seems to make that worse, in that the parties are requesting that the arbitrators abide by 90 days. It is no longer a firm 90-day deadline. So there are some ways where it takes it in the wrong direction from a US perspective. And other ways where it certainly solves for a problem. So there are different ways to do it. I think that members are going to have to work out what the dispute settlement mechanism looks like, but I don't think it's fair to say that not having an appellate function is going to lead to banana republic and a total breakdown of the rule of law, because that's simply not the case from my perspective.
Okay, so I think we literally have 4 different, sometimes interlocking positions, sometimes diametrically opposed positions on this debate. And we can't get into everything. The point of this series is to, in this first kind of plenary session, just throw it all out there. I wanted to find out if there were any reactions from the panelists about, well, what happens, because we know one of the, let's say, the most litigious, strongest members, the United States, has decided to come out in their letter almost against the MPIA. What happens now? What happens in terms of reframing the discussion? Is it going to lead those who have already signed on to go even further in developing it and trying to get countries to join in? Is it going to signal to those who have not joined, as Kellyanne suggested, that there are other alternatives out there? I mean, we're moving towards a system of increasing, potentially fracturing, fragmentation of dispute settlement approaches. And that's going to have a necessary impact on how dispute settlement is conducted at the WTO. And I fear for that in terms of fragmenting a system that has always been at all levels about single undertakings. We know the JSI initiatives is signaling a direction towards more plurilateral initiatives, but has the time come now for dispute settlement to go that way? So I guess I'm throwing out, what does this mean for the system that we understood the WTO to represent? And what are the consequences of that kind of fragmentation of dispute settlement? I wonder if I can throw that back to you, Mustaqim, to start us around the broader consequences of the MPIA on the broader WTO framework.
Yes, thanks, Geneva. I certainly take the points of my colleagues on this panel, but in many instances I don't share the optimism because, of course, as a government representative, there's always the systemic issues, and I think the most important point here is that, like the JSIs, the MPIA represents certainly an escalation of the plurilateralization of the World Trade Organization. And so is it that we will transform this organization into an exclusive club where you have those who have and those who do not have? And certainly the MPIA would be the basis for this. Now, given the fact that South Africa has objected vehemently to the JSIs based on the mandate of the WTO, based on the unfinished business that we have in terms of the Doha development round, and as you rightly point out, the single undertaking, we believe that the MPIA is likely to exacerbate these particular dynamics. Now, take, for example, the MPIA, which is binding on that join it and applies to all disputes, which includes future disputes. And so think the fact that the JSI members could complete a JSI on investment facilitation or e-commerce. The MPIA becomes the de facto enforcement mechanism in the absence of common rules. And this is a grave danger, because certainly it turns the developmental argument on its head. And secondly, it creates a dangerous precedent, because we understand also that before we concluded the Uruguay round, we were stuck with a whole lot of Tokyo round codes. And these codes de facto became the basis of negotiation. And certainly if you look at SPS, TBT, and so forth, these were translated into multilateral disciplines. And so at the end of the day, we do not believe that instruments such as the MPIA would necessarily facilitate the kind of multilateral organization that we want. And certainly, when push comes to shove, we have many more concerns with how this will be operationalized and what the systemic effect of this agreement will be on the broader membership. Now remember that all of us signed onto this agreement, the Marrakesh Agreement, and all the covered agreements associated with it on the basis of certain rights and obligations. So a small subset of members cannot now go and certainly amend, as far as we are concerned, the dispute settlement understanding without going through the amendment process, which is clarified in Article 9 of the Marrakesh Agreement. This certainly cannot be acceptable, and certainly also we believe that on the issue of cost, Article 25 could be available for any matter that members may want to apply it to. But in the way that it is being applied now, it goes way beyond what even the founding fathers, the negotiators that negotiated this particular understanding had envisaged, because it was always the understanding that there would be an appellate function. And certainly I would take issue with what Kellyanne said, that the application of a two-tier system where you have an appellate function is not that important. I think it's quite important for consistency and predictability. And certainly I would agree that as an afterthought, it was added, not because people thought it was sexy or something like that, but there were many concerns from the GATT era that egregious mistakes made by panels and working parties would not be fixable if you did not have a second tier of oversight. So whereas we agree that a two-tier system is perhaps the best guarantee for the rights and obligations of members, we certainly would have problems if the tail starts to wag the dog, that in the sense that members now create new rules that other members did not consent to, and at the end of the day, some sort of consideration when these are brought back for a multilateral interaction. Thanks.
Hi, can I jump in now? Hi, Chad. Yeah. Okay. So again, I think I'm completely with Mustaqim in terms of the dangers that the joint informal processes relating to e-commerce and domestic regulation, investment facilitation, etc., that are ongoing, and the fact that they pretty much strike at the core of the entire WTO system, which is premised on consensual decision making. But where I again see a difference with the MPIA, because Mustaqim had characterized MPIA 2 in the same box of a plurilateral. The difference that I see, Mustaqim, is that this is really the MPIA, which is premised on Article 25, which is already part of the statute book, which is already part of a consensually arrived mechanism, is really an agreement between certain countries to not simply let a panel report that those members may want to appeal to become defunct because of the lack of an appellate body. So it is really a creation or an act of faith and an act of principle that they would, instead of simply letting a panel report be, they would actually resort to an effective dispute settlement through the second tier, which in the absence of the appellate body is the MPIA. So it's really about a mechanism to ensure the enforcement of all the agreements and rules and obligations which have been arrived at on a consensual basis. You raised the issue of the fact that, how is this going to apply to future agreements? And that's interesting because clearly, as you're aware, the joint informals are really not about a cohesive group of plurilateral members getting together. I mean, it's again, it's a coalition of convenience and coalition of the willing across all the joint informals. In fact, the US is present, as far as I think, only in the e-commerce grouping. And the US is never going to agree to an Article 25 process. So even if there is a future agreement, assuming on the e-commerce, on the subject of digital commerce or e-commerce, as the case may be, Japan and the US, I don't see ever agreeing to an enforcement mechanism or an appellate review process through the MPIA. So with regard to the other joint informals, I think each of them has its own dynamics, each of them has its own complexities. I completely agree in terms of the dangers that they present to the entire WTO system, but how are they going to become effectuated is an issue of which will need to be, you mentioned the fact that there need to be an amendment to the WTO agreement. So clearly, yes, if this needs to be embodied as Annex 4 type of plurilateral agreements, they have a consensus decision agreeing for them to be so. On the other hand, the type of innovations that are being talked about, at least in the context of, say, the domestic regulation joint informal, is that this will manifest in the form of Article 18 additional commitments under GATS, which will then be MFNized by the members that have agreed to it. Again, these are issues which are just being talked about. They haven't really been crystallized. But in any event, for all of this to become part of the WTO is, I think, a little bit, is some time away. I completely agree with the fact that, the issues that are in the limbo, issues which are unresolved, which have simply been put aside, you mentioned the Doha round of issues, are absolutely crucial and critical. But the fact of the matter is that while there are a plethora of aspects on which WTO reform needs to happen, developing country issues need to be addressed. On the issue of MPIA, I think I wouldn't extend it to the extent of becoming a plurilateral, because that will in effect then disintegrate the entire WTO itself. It will then mean that only the 21 members as of now that have agreed to the MPIA will actually accede to the appellate review process, or as Kellyanne mentioned, for the others, the only other option really would be either consultation or negotiate settlements or be happy with the panel report. But the bigger danger, Kellyanne, is when there is no compliance with the panel report because of the fact that there is, out of convenience, a member may want to just appeal it into the void. And for the winning member in a panel stage, which is unhappy with the fact that the member that has lost a dispute has actually not implemented a report, a panel report, would that mean, would that result in unilateral actions, unilateral retaliation? And that is where I think that the fact that there has to be an agreed system of rules to resolve this and not simply leave it to member convenience on a case-by-case basis is something which needs deeper reflection.
Thanks, Anuradha. Before we kind of go to the other panelists, I recognize that maybe the viewers here come from, the WTO Dispute Settlement community who understand all of these concepts of JSI and appealing into the void and all of these extremely specific terms. But if we could kind of step back a little bit as well as you think about these issues that have been raised, I mean, is this a case again where developing countries and those who utilize the system less, as I think Mustaqim has raised this issue, will become even further isolated from the system? And is that something that we can afford, even if it's on an experimental basis, through this MPIA? And I understand that it has been developed to fill a big void in the interim. But is there a real risk here that this becomes the permanent, and this becomes the permanent for some? And even if some decide to come up with another, alternative, as I think Kellyanne has suggested, there are things that we could do other than the MPIA. My question is, again, what is that doing to the system at the WTO? And is that something that we can afford to experiment with as is? Or is the MPIA something that we can, because the rules and the procedures under the MPIA do provide for members of the MPIA to develop their own procedures as necessary? I mean, what they suggest are certain procedural innovations, and some of them mimic exactly the appellate review process. But there's also within, from my understanding, the MPIA context, the ability for those who are members to go off and further innovate in the way that they deem fit. So I guess Claude and Kellyanne, what are your views on these issues?
Sure. I'm happy to jump in. And I actually think it ties very closely with what I was going to say on your last question anyway. And sort of what are the risks associated with doing this? You know, there are two things that I see. You know, one has to do with jurisprudence and what happens to that jurisprudence later, which we had already touched on, but the other has to do with resources. And this, I think, ties nicely to the point you were getting at. You know, there are a finite number of resources in terms of time, attention, money from members. There are only so many issues that can be tackled at once. And the more oxygen that is taken up trying to get this off the ground or trying to address the appellate body situation, the less time and oxygen is given to the more fundamental question that is being posed to the institution as a whole. The WTO is an institution in search of a purpose. It is not currently an organization that is able to effectively address modern economic challenges. And I am a supporter of the system. I have spent the last 10 years working on it. I want to see it reformed into one that can actually address those challenges. But the problem is we have a director general who has stepped down. We have an appellate body that is no longer functioning. We have a ministerial that was supposed to happen last week that was pushed back a year because of COVID. But even on the agenda were e-commerce, the moratorium, as well as the fish subsidies. And there was a real question mark as to whether we were even going to be able to agree on those. We have committees that are meeting virtually, but there's even a question, I've been told by some delegates, as to whether they have the authority to adopt meeting agendas because they can't make any meaningful decisions at this time because of the virtual situation. So we really do have an organization that is in paralysis, that has not really done anything significant on a multilateral basis in a number of years. And there does not seem to be a path forward. The WTO is not at its core an international court. So if the only thing that is working is dispute settlement, I think we have a bigger problem than we're actually talking about. So it is a question of resources. And I do think that there is a trade-off. The more time and effort we spend working through the procedures, recruiting members to get on this interim temporary system, the less time we have thinking creatively about how to address some of the other challenges. My personal view on the dispute settlement mechanism and some of its shortcomings related to judicial overreach is that we are putting arbitrators, appellate body members, and panelists in an impossible situation as member countries. We are saying, here is our modern challenge related to state-directed economic activity, the digital economy, something that was not contemplated when we negotiated the rules in 1994. And we are saying, please solve this problem for us, but do not engage in judicial overreach. Do not bend the rules to mean something that we didn't intend 30 years ago when these problems didn't exist. It is an impossible task. And until we are able to jumpstart the negotiations and to do something meaningful on modern challenges, I think we will continue to see problems in the dispute settlement mechanism.
Claude, I wonder if you have anything to say about anything specific Kellyanne said or any of your other panelists on this topic of what does this really mean for the system?
In terms of what it means for the system, I suppose, you know, I'm just not convinced that not having the MPIA is going to solve any of the issues that Kellyanne referred to. I mean, these are long-standing issues. The negotiating function has been there for a long time. On the other hand, you had a function. Balance between two functions that they put the powers in a situation. I agree with Kenya. I think it tracks back to that, you know, being put in positions where you're having to interpret a particular factual situation and to deal with these modern issues. What I'm having trouble sort of connecting is I don't see how not having an MPIA will address all of these issues that are really long-standing. Again, I think we need to contextualize the MPIA, and we can't use the MPIA to try to solve everything else. I think we have to see the MPIA to address a very specific issue. I go back to what I said earlier, which is that I disagree that the dispute settlement function can continue to operate right now. I think right now we are in a situation of non-binding dispute settlement. I think as a fact, simply because members retain the right to appeal to an appellate body that does not exist. So that's not a mere possibility. That is the status quo. And I think right now, if we want to have a WTO with a dispute settlement function, then we need to think about ways to solve that. Now, the MPIA, I agree, it might not be the only option. But then that brings us to another question. If there are other options, why aren't they being put on the table? In a sense, the MPIA is suboptimal, but it's the only game in town. There is nobody else putting forward other alternatives. Alternatives that have been put forward would require, consensus, would require amending the treaties. And we all know that, the possibility of that happening is slim to none. And that's why I see the MPIA as it's a stopgap measure. It's clean because it maintains what's already there. And I do sort of hear a slight contradiction in the sense that I sense that there's this fear that with the MPIA, we're doing something that's new, and you might be imposing on other members something that's new, and you might be amending the treaty. Yet you hear the criticism that, oh, the MPIA is just replicating the appellate body. For me, that there's a slight contradiction there. It's either it's new and it's amending the treaty, or it's not. And I think, I think it's not. I agree with everything that Kellyanne has said in terms of identifying, the issues facing the WTO right now. But what I just don't think that holding the MPIA or the future of the DS system hostage will solve these issues.
I wonder, as we get to the last topic, thank you, Claudia. You had some, I don't know if everybody heard it, but there were a little bit of some audio issues that may have compromised what you said, but I think we heard everything in the end. But the last kind of topic I want us to get to, again, just touching issues and getting a pulse of where, different people lie on this topic. And it kind of, for me, validates why I wanted to have this talk, because I wanted to hear what your views were. But I am from a developing country. I'm from a small developing country. We don't use the system. I would say there are 10 countries that use the system as a viable part of their toolkit. And so it gives them options that the rest of us who don't have it, because of really costs and resources associated with utilization of the system pose, for whom dispute settlement is not a reality. It's just not something that we are engaged in. It's not something, and it doesn't mean it's not something that could be important to us. But as you're speaking here, you're speaking to membership of all 164 countries of the WTO. The MPIA discussion has become a topic that only a few seem to care really about. Those are the users and some who are non-users but are sympathetic to its aims. How do we move from here? Is it that we move to try to reform what is already in the MPIA, which we know is already started? That process has started through the selection process. I know we have said there's some issues there. There's some objections to certain of the aims and whether it should be financed through the budget. But should we keep the MPIA and find a way to fix it? Should we think more broadly? I think Mustaqim said special session, and Kellyanne, special DSB review sessions have been happening for years, where a lot of the developing countries who do not utilize the system have voiced concerns. We have issues of representativeness. How representative are those selected? And will the MPIA perpetuate a system of elite arbitrators deciding the cases, well-qualified ones, but certainly those who will be selected would be nominated by the parties to the MPIA. So these are issues that have sort of come up, and I'm just wondering, where do we go from here, thinking about a dispute settlement system that belongs to all, and hearing a lot of your concerns that MPIA is a stopgap measure, but what are we saying to our community about dispute settlement and who it belongs to ultimately? And is MPIA perpetuating the problem or really solving the problem? And I'm just putting it out there as we close your discussions, and then we'll go to some of the questions. I want us to think about some of the fundamentals of dispute settlement and who it's really serving and what MPIA is really doing to that broader question. So if we can go around, maybe we can reverse the ordering, but Mustaqim, I see you have your mic off, so maybe you want to start us off.
Yeah. Let me try and dive in first. Yeah, I think it's, you know, manifest that we have not been honoring our obligations. As members of the WTO, we have allowed this organization to become dysfunctional. And so insofar as members have agreed that the dispute settlement system is an outsourcing based on certain parameters, I certainly think that members have to play their role. We cannot rely on panels and the appellate body to fix issues which are not technical. These are political issues, and they have basically come in many forms and shapes. And so ultimately, you cannot use dispute settlement as a payback or as a hostage to achieve other negotiating outcomes. So I think the first point is here that members should buckle up. Members should take responsibility. What does that mean? In the first instance, members act in the absence of the ministerial conference through the council as the premier interpreters and guardians of the WTO covered agreements, including the DSU. And so we would think that members should take that obligation quite serious. And so politically, I would think that is the problem. If you look at the success of the dispute settlement system, it is the most successful multilateral quasi-judicial system in the world today, in the last 50 years, in the last 150 years, probably in the history of dispute settlement. We have had more cases combined with the other bodies that have multilateral jurisdiction. And so my question is that the system has become a victim of its own success. Have there been failures? Have there been mistakes? Yes, there have been failures, there have been mistakes, but we have various means to fix this. Now, the fact that certain members choose to privilege the MPIA does not fix the fundamental political disconnect. The US calls this a China-EU agreement. And so ultimately, we need to think about the political context here, because the dispute settlement system has been taken hostage, and until and unless we have this political will to fix it, nothing is going to get fixed.
Is everybody else coward after that statement, or can I get go ahead, Kellyanne?
Sure. You know, it's yeah, I think, you know, coming from the perspective of the United States and working for my country for 10 years, I certainly take a different perspective than other folks on the panel in terms of the appellate body. And, you know, for years, I, along with colleagues, worked with other members, worked with allies, worked with friends, worked with anybody who would listen to us in the WTO framework to talk about what to do with the appellate body and to talk about what to do with dispute settlement reform. There were formal negotiations, but there were also side meetings. We had texts proposed, amendments proposed. We got together with coalitions. We lobbied. We did everything we could. And there was no meaningful engagement on these issues in the end. There was a recognition that there were issues, but there was no solution moving forward. And that's ultimately why we got to the situation that we're in. But at the same time, I do think it is important to take the broader WTO framework into account when you're looking at the MPIA, whether you call it the EU-China agreement, whether you call it, you know, whatever, because we have an institution that cannot make progress on any front. It can't make progress in terms of negotiations. It is stuck in terms of its monitoring function, and it is certainly stuck in terms of its dispute settlement function. We need to take our resources and think about what we want to do to take the WTO into the 21st century. I don't necessarily think that spending a lot of resources and energy on a temporary interim measure that locks in and frankly makes worse some of the issues that have been identified with the dispute settlement mechanism is the best use of resources. That said, if countries want to do it, I think that it's their sovereign right to do so, and anyone who wants to participate absolutely should do that. Ultimately, the aim of the dispute settlement system is to resolve the dispute between the members. And Johnny, you asked for countries who don't participate in the system what that means. Certainly it also provides security and predictability with respect to the commitments. It also clarifies provisions in the agreement. There is a benefit to all of the WTO membership, which is why there's a real question with what the jurisprudence of the Article 25 arbitration would mean for the entire membership, and whether that would lock in certain outcomes or prejudice certain outcomes in negotiations or in agreements moving forward. But ultimately, we need to resolve the broader question about what to do with the WTO. And I just don't want to see a lot of time, energy, and resources being funneled into something very specific when we're burying our head in the sand with respect to the entire organization.
Kellyanne, before you mute your mic, I mean, and I know you're not here speaking in your previous capacity, as a representative of the U.S., but where would you advise, if you could, your government to concentrate resources now? Because I think the big elephant in the room here is, well, what should you do, U.S.? What do you propose we actually do? I think a lot of the innovations have been introduced in order to try to meet some of the concerns that have been raised, as you say, historically by the United States. But I wonder, what do we do now? And again, I'm not trying to put you on the spot, but where would you advise your government, if you could, to funnel its resources right now?
Yeah, well, with the WTO generally, again, I think it is an institution in search of a purpose right now. It is not equipped to deal with modern challenges, which bleeds into the dispute settlement mechanism and the judicial overreach and the impossible position that arbitrators and appellate body members are put into. But I think you have to look at what are the real challenges we're facing right now. It's state-directed economic activity. It's questions related to the digital economy, which simply didn't exist, and try to come up with solutions around those topics. On dispute settlement generally, you absolutely need an effective enforcement mechanism and tool. There is no question about that. But there has to be a meeting of the minds between members as to what that looks like. And the DSU, as it was set out, was intended to be temporary as well. There was going to be a 4-year review period where members would get together and then make any modifications necessary for it. So, whether you in the interim have binding panel decisions while members work out what either a second tier review would look like or some other form of enforcement, I'm not sure. There are different ways to do it and to go around it. And, I said from the outset, I don't think that an appellate mechanism is a necessity. I think it is a choice, and it may be a preference. It may be preferable for everyone, but it is not a necessity in terms of having effective enforcement.
Okay, I think I'd like to jump in here too. So I think there are again a few distinct issues, Jenny, that that have arisen. But among the key aspects that I'd like to take up is the first issue in terms of is the WTO ill-equipped to deal with modern challenges, as Kellyanne characterized. And this I completely disagree with the assumption that it isn't. Because to a large extent, the framework of rules and regulations that we have within the WTO agreements still hold valid, whether it is regulations in terms of the agreement relating to goods, to services, to standards, to trade remedies. All of these are issues which continue to occupy critical regulatory space. These are issues on which countries will continue to have disputes. The fact that there haven't been new negotiations and new agreements on issues which, the Doha round issues, which have now been characterized as not relevant, not constituting modern challenges, and that modern challenges are only those pertaining to the digital economy, is something I would take issue with. The fact of the matter is that there are waves of change, there are concerns on a variety of aspects, and these are not necessarily going to be characterized as developing and developed countries related issues anymore. There was this very interesting report that UNCTAD had come out 2 years back, the Trade and Development Report, titled, I think, Power Platforms and the Free Trade Delusion, and I really liked the topic because what it essentially said was a statement of fact that the paradox of our century, the 21st century, and the new issues that we're dealing with is the fact that practically all countries, advanced and developing, are becoming increasingly brittle, sluggish, and fractured. And one of the issues one of the aspects and criteria that it attributed this fracturing to is the fact that the trade agreements, the rules that have been formulated, really is creating a small set of beneficiaries, which are increasingly global businesses without accountability. It's really concentrating power and enhancing that rather than regulating it and addressing issues of development meaningfully. Now, in that context, clearly there is going to be a divide in terms of how new issues on digital economy, which in countries like ours, like India, it is an evolving set of regulations. It is something which we are grappling with. We are still putting in place the domestic regulatory frameworks. And it takes us back to this fundamental issue of whether international lawmaking and international rulemaking should be the one dictating how countries actually develop their own autonomous regimes, or do countries develop it autonomously and then agree to an international framework? So it's really a question of a bottom-up or a top-down approach and what really best fits. But within all of this, to say that the absence or the inability of the WTO to address one or two specific issues is going to render the entire institution meaningless, the fact that the entire set of agreements which have withstood the test of time, which are going to continue to have relevance with increasing servicification of the economy, for example, I think disputes under GATS, the interpretation of very crucial aspects relating to commitments under the various schedules of members is something which is only going to increase with time. And the WTO will have relevance for all of those. And by completely taking away the appellate process, by saying that, okay, it may not be important or it has no relevance without an actual amendment to the DSU, I think is not really going to lead to a meaningful solution to the whole aspect. I completely agree with the fact that we need a concentrated, a good faith negotiation to resolve it. But the fact that a number of these issues were discussed, were actually laid out, and alternatives were presented, and yet there was no agreement during the Walker process, to me was a huge disappointment. So where do we go from here? Do we simply replicate the Walker process, start from there, and further refine it? Perhaps that's one way. Is it something that we then, or we say that, okay, the appellate process should be completely done away with? I don't see that as a starter at all. I think either Mustaqim or Claude had mentioned the point that the appellate process was really an additionality to the earlier GATT process, which was perceived as being of critical importance in order to ensure that members have greater faith and trust in the system. And it has certainly served that function. So how do we address the fault lines, the common concerns? That can really be done only if there is a meeting on the side of all the parties involved, all the countries involved.
Claude, I wonder if you want to conclude before I went to the questions on any of the points raised.
No, I think I would agree with Anuradha. For me, I think when I listen to everything that's been said, we've changed the title a bit, in the sense that the title was Can the MPIA save WTO dispute settlement? But I think from a lot of this discussion, I think we're asking of the MPIA for it to save the WTO, not WTO dispute settlement, but to save the WTO as a whole. I don't think that's what it's meant to do. I don't think it can possibly do that. I think we all know what the issues are with the WTO at the moment. We know that there are issues with respect to its negotiating function, how quickly new rules are being negotiated to respond to modern challenges. There have been issues raised with respect to transparency obligations, etc. And all of these are valid. But I just come back to the point where I think we're asking too much of the MPIA. And again, for me, what I have not heard is, if not the MPIA, then what is the temporary solution to ensure that the WTO maintains a dispute settlement function? And for me, it's absolutely clear that in the absence of the appellate body as it stands now, we don't have a strong and credible dispute settlement function simply because panel reports are not binding. And that could lead to a situation where we start seeing unilateral trade barriers being erected. Because the point is that if you would have to go through a panel process and ultimately end up at a stage where you couldn't use the enforcement tools under the DSU because a member appealed into the void, and you were somehow forced to resort to a unilateral measure to enforce a compliance panel report, then you might as well not go through the process. After a while, this might be the situation that we're in. So I think we may not be recognizing that there is a very immediate concern that needs to be addressed. At the same time, I do agree that it cannot be the permanent solution. We do need a permanent solution. And I completely agree with Anuradha that it's instructive that that before the MPIA really sort of before it really had traction, there was an initiative to try to solve the issue through the Walker process. And there were good faith efforts. There were proposals put forward. If you look at the Walker text, in my view, it addresses a lot of the concerns that were put forward, and we still haven't managed to move forward. And so the question is, if it is that we're not going to move forward, or for some reason we are unable to move forward, what should happen in the interim? And that's where I think the MPIA comes in. Personally, I haven't heard yet of a credible alternative to the MPIA. And so I think if a few member states want to preserve for themselves the binding dispute settlement and the right to appeal a panel report, then I think, that's their sovereign right. And I mean, just finally to conclude, I mean, this idea that that appellate review is optional, I would disagree with that. I mean, appellate review is a characteristic of the dispute settlement system as we know it. It's in the treaty. This is what members agreed to in the DSU. They established an appellate body. They made it part of the system. And in fact, they actually also agreed to appoint appellate body members as vacancies arose. And that's an obligation that has not been complied with. And I think in the absence of that, member states who want to preserve the right of appeal that they have under the DSU should be permitted to do that.
Thank you, guys. This was excellent exposition. We have a few questions. I'm not sure how I'm going to tease them out, or if it will not be a perfect reflection of the scale of the issues raised by our viewers. And thank you so much for your questions. But just a last point on what Claude just said about the members actually being free to preserve their treaty-given right to appeal. And with the current number at 21, how likely is it that the system is actually even going to be used? Because those who are involved in the panel stage, many of them have not signed up. So we may be talking a lot about an MPIA that, one, may not get off the ground for reasons we talked about, like the budget, but we'll hear what the EU and the other proponents have to say. But two, the chance of it being actually utilized are few and far between, because it has some of the main litigants, but certainly not all. So it may just be a lot about nothing in the end, but I guess we have to see what happens. So if I start with the top set of questions that were raised, and I'll try to get in the next 10, 15 minutes as many in as possible. Start with Stuti Toshi, who asked, while the MPIA is being introduced as a transitional temporary measure, would the panel perceive a risk of the appointment process and it actually becoming redundant? So is it really a case that whilst the MPIA is ongoing, that we try to resuscitate, I guess, the appointment of appellate body members, or is that system really dead and we are going to have to try something new under the MPIA? A second question from Tanya Radza, and I'd ask any panel to jump in on any I'll take three. Is the MPIA is a plurilateral arrangement that would divert members from dealing with the actual crises within the WTO. The absence of the USA from the MPIA renders its efficacy doubtful. That was a comment. Hannes Schloman asked, I think, two questions, but I'll take his first. In a curious way, he says, the MPIA and its genesis confirm the US's point. Dispute settlement is a service trade that rendered to the disputing parties, not the institution or the membership more broadly. So it's entirely logical, he says, and legitimate to have a small group plurilateral solution. And does that logic delegitimize the MPIA as a rescue patch for the system, as some of the MPIA proponents see it? So sort of three different questions. I'd be curious if you had any comments on, first, about the appellate body appointment process. Is it really dead? Are we going to try to resurrect that? And then Hannes's question about you know, what the intentions of the MPIA as being for a smaller subset of members, sort of fulfilling its actual purpose. I wonder if any of the panelists has anything to say or offer on these questions. Mr. Keem.
Yes, I'm always first, but perhaps just on the first question, I think we should remain optimistic to reconstitute the appellate body. I think, as many of my colleagues, there is something such as the Walker process, a useful tool to tease out possible areas of convergence. But I will say that there is another process in the DSB under the so-called joint proposal, where 120 members of the WTO are calling for appointing appellate body members, starting selection processes, and so forth. So it's not as if nothing is happening. I think this is a continuous process, and we need to be optimistic. Now, of course, there are concurrent issues that may pertain in respect of the MPIA. Many of these would have been pointed out. But I wanted to say the comment by Hannes Schluman, and certainly also from the EU, that characterizes the MPIA as a so-called life-preserving machine, an ICU for the appellate body, is totally misdirected. Because if you look at the dynamics and the setup of the MPIA, it might as well have been set up on Mars, because it has nothing to do with the multilateral oversight which members have agreed to. And so certainly I would disagree that the MPIA has any useful examples or even experience to render in respect of those members who are not part of it.
I wonder if anybody had any comments on the last set of questions, but I think Shaila Singh has a very interesting question that I would want to throw back into the mix. She would welcome your views on the EC proposal that the EU impose unilateral countermeasures against members who A, appeal into the void. So after a favorable ruling, they decide, for the other side, they actually, or in favor of the EU, sorry, that they actually agree to appeal into the void, where the countermeasures in that context by the EU would be a good idea. And two, members who have not joined the interim appeal arbitration mechanism. So the countermeasures by the EU imposed becomes a sort of a means of enforcing those who decide to join the MPIA and encouraging more members to join the MPIA, but also as a way to get at those who appeal into the void when the EU has a favorable ruling. I wonder if any of the panelists have a view on that, Claude.
Well, I mean, if I could jump in here, I think, you know, the EU's proposal highlights the problem. If you are litigating a dispute and you are the complainant and you have won and you have a successful outcome, and the panel has ruled that, you know, the respondent has violated its WTO commitments, and we have to remember as well that, you know, behind this dispute, we can look at it in technical terms. There's an industry, for example, that has been subject to a WTO inconsistent measure. And as the complainant, you want to be able to have the respondent comply. Now, if you are unable to do so because the respondent has appealed into the void, which in my view, you can characterize that as an action that is not in good faith, then what is the complaining party left to do? The only thing that it can do is to take unilateral action. So I actually think that that's where we are headed. I think if the situation remains, you will see members seeking to enforce panel rulings by taking unilateral measures. And that's a consequence of not having any alternative. And so I think that's natural. I wouldn't make, in terms of a value judgment on it, from the complainant's perspective, if it's forced in, and I think, the EU makes reference to sort of broader international law, which allows you to take countermeasures in that particular scenario.
And this is really an interesting development. Anuradha, as you think about what you'd like to say, let me just ask, because we have 4 or 5 minutes left. Pamela Cook-Hamilton asked a more technical question, and back to the technical components of this question is, so this precedence created by the MPIA arbitrators, what happens when the appellate body is fixed? If it's fixed, what happens with that body? Well, we don't know how many, MPIA disputes there will be, but what happens with that? What's the status of that existing case law? Does it merge back into the broader waters of appellate body jurisprudence, panel jurisprudence? Can panels refer to what was said in MPIA decisions for parties that were not party to it? I wonder if any views on that or any of the other questions raised. Anuradha, and then I'll ask Kellyanne, and then we can close off.
Yeah, I think again on the issue of precedents, I think the Walker process had come up with a suggestion that precedents are actually not created through WTO dispute settlement proceedings, but at the same time there has to be the principle of consistency and predictability in interpretation of rights and obligations. I would, from a very technical perspective, an MPIA process, an arbitration process, would at best have a persuasive value for an appellate body as and when it is resurrected, but certainly not anything beyond that, which is again the case as it is right now. It is really the case with any of the the other body of international law, for example, BIT disputes, for example, where arbitration panels typically refer to principles that have been decided in other cases. But I do not see it having any more of a value beyond that. But I think also just getting on to the issue of what would all of this, what the MPIA process as a whole really have a value for. I think it's really a stopgap arrangement. It has a very limited value, but EU's proposal on countermeasures I see as being dangerous and risky, purely for the reason that it is seeking to legitimize a unilateral action, which I think is fundamentally something which cannot be justified under the WTO process. If there is a problem with the appellate process, that needs to be fixed, rather than place the onus on a losing member to bear the brunt of a lack of an appellate process, or the choice that that member has made in not joining the MPI process, which could be for a variety of reasons. So what might actually practically happen in the form of chaos and unilateral measures being sought to be justified as justified rules of international law, I find it highly problematic. And I think there are, again, critical issues under the draft principles of the international of state responsibility of the INC that the EU was trying to justify it under. I don't think there's any consensus on that. And again, we will never have a dispute settlement proceeding to actually rule on that. So it's really going to be EU's word against another. So overall, I don't see that as a solution.
So appearing on your screen would be, thanks Anuradha, would be a question that we set out to ask, which is, can the MPIA save WTO dispute settlement? And I'll invite you, audience, because the panelists can't vote on our poll, to answer the question. Maybe some of the panelists have convinced you or not on the answer to that question. As we round off, and I want to give Kellyanne an opportunity to close off her views because we're at the end time of our session today. Can I ask the panel by a show of your hands if you think on balance that the MPIA can save WTO dispute settlement? And the options are yes, no, I don't know. And you have to vote. So of the four of you, how many of you think the answer is yes? 1, 2, I'm not surprised. No, it can't save WTO dispute settlement. Kellyanne. Mr. Keem, does that leave you with I don't know?
No, it means no, it cannot save either the DSU or the WTO, as far as I'm concerned.
Oh, you thought this was an incomplete question. So I think maybe I'll ask Kellyanne because she hasn't had her last intervention, and then all that's left to do is for me to thank you all. So Kellyanne?
Thanks so much, everyone. No, I don't think it can ultimately save dispute settlement. You know, it's going to take an agreement among members, a meeting of the mind to save dispute settlement. And I also think a restarting or an injection of lifeblood into negotiations to save dispute settlement. But, you know, ultimately, I think we've had a great discussion today, a number of good points, obviously different perspectives and views. But what's clear is that we're all seeking a way to improve the WTO, including having an effective enforcement mechanism tool. And, you know, from my perspective, it can take a variety of shapes, sizes, and forms, but everyone has an interest in getting their matter resolved. I also question the proposal by the EU. It seems more like a messaging tool than something that would necessarily be wise-minded in terms of unilateral enforcement because there are risks associated with that. But, you know, countries have a right to form whatever types of arrangements they want. And ultimately, what I've seen in 10 years of working in the WTO system is countries be practical. I mean, we don't know just from the DSU itself what comes first, you know, Article 21.5 or Article 22.6, but yet countries came up with sequencing agreements to address that problem. I think that ultimately we'll probably see an increase in sequencing agreements here with commitments to abide by a binding panel report to deal with the lacuna in the meantime. But hopefully there will be a long-term solution to what to do about dispute settlement, because again, I do think that all countries share an interest in having effective enforcements of the commitments.
Well, thank you so much. We have the results of the poll. I don't know how many people are left because I know we had some attrition, I guess because we were 3 minutes over our time, but that was 3 minutes worth listening in for this lovely discussion. But drum roll. So 20% of our attendees thought that yes, the MPIA can save dispute settlement at the WTO. A resounding 67% are doubtful and say no, it cannot. And 19% say I don't know. Of course, there's nuance in all of these answers. We didn't give people an opportunity to write why they said what they said. But I want to, first of all, thank my global group of globally representative set of panelists for allowing us to take the debate from where it is in Geneva and democratize it so that we can all share in our thinking about what this means for our cherished system, whichever part of the debate you fall on. I think we all want to see the WTO do well. I think that's the one thing we can all agree as panelists is that we want to see the WTO succeed. Thank you to the listening public. We want to host a second webinar where we may take one issue, bring in again new voices to the discussion, and I'm in discussions already with that. Thank you. I know Zoom talks are everywhere. Thanks for joining us, and we look forward to having another session. So thank you all, and thanks to all of the IT experts here in Barbados, and we'll see you next time. Thank you all.
It's who we are. Yeah.